Hello everyone, welcome to Courts Today by Live Law, your go-to source for the latest and fastest legal updates. I'm your host Urvashi Chauhan, here to bring you daily developments, landmark judgments and significant rulings from the world of law. Let us begin with the headlines and a concise overview of the top stories, and after that we will delve into the full details. The Supreme Court has today restrained the Union and states from acting on the NCPCR letter to close madrasas that are not compliant with the RTE Act. The Supreme Court has dismissed Arvind Kejriwal's plea against Gujarat University's criminal defamation case for comments on PM Modi's degree. In a status report to the Supreme Court, the Kerala police has recommended against granting bail to Malayalam actor Siddiki in the rape case. The Supreme Court, while hearing plea against amendment to the Preamble, has said that secularism has always been held to be part of the Constitution. In the Rajasthan civil judge exam case, the Supreme Court has sought to know marks of law papers of candidates who scored low in the English essay. In the defamation battle with ANI, the Delhi High Court today told Wikipedia that there is nothing worse for a news agency being called puppet of the government. Saying that Finance Ministry cannot treat DRT officers as subordinates, the Supreme Court has reprimanded Centre for asking DRTs to collect data. After blame game between senior advocate and an AOR on a false statement case, the Supreme Court is considering guidelines on conduct of advocates on record. And the Supreme Court has allowed Justice Jayant Nath to continue as DERC Chairperson regardless of retirement age. The Supreme Court today restrained the Union government and the states from acting upon the communications issued by National Commission for Protection of Child Rights, that is NCPCR, to withdraw the recognition of Madrasas which are not compliant with the Right to Education Act 2009 and to conduct an inspection of all Madrasas. In June this year, the NCPCR wrote to the Chief Secretary of State of Uttar Pradesh directing that the recognition of madrasas not complying with the RTE Act be withdrawn. Then on 25th June this year, the NCPR wrote to the Education Ministry to issue directions to all states and union territories to conduct inspections of the existing madrasas with Unified District Information System for Education, that is UDIS code. The recognition and UDIS code of madrasas that do not comply with the norms under the RTE Act 2009 were sought to be withdrawn with immediate effect. The NCPCR also requested the union to not extend the UDIS system to madrasas. It also recommended a separate category may be created to capture information about all madrasas, including recognized, unrecognized and unmapped ones. After this, the Uttar Pradesh Chief Secretary wrote to all district collectors to conduct a detailed investigation of all government-aided and recognized madrasas in the state and admit non-Muslim children and to ensure immediate admission of all children enrolled in madrasas into schools. A similar instruction was also issued by the government of Tripura. In July, the Union government wrote to all states and union territories to take action as per the NCPCR's instruction, challenging these decisions as an infringement of the right of religious minorities to impart education. A petition was filed by Islamic clerics body Jamaat Ulema-e-Hind. Today, the bench comprising CJI D.Y. Chandrachud, Justices J.B. Pardiwala and Manoj Mishra issued notice and directed that pending further orders, the communications of the NCPCR and further of the union or states shall not be acted upon. The Supreme Court has today dismissed the petition filed by former Delhi Chief Minister Arvind Kejriwal challenging the criminal defamation case filed against him by the Gujarat University Registrar over Kejriwal's remarks about Prime Minister Narendra Modi's educational degree. Kejriwal had approached the Supreme Court challenging Gujarat High Court's order, which had dismissed his petition challenging the summons issued in the defamation case. The background of this matter is the defamation case filed by Gujarat University against Kejriwal and Sanjay Singh in connection with the remarks made by them against Modi's academic degree. The complaint, filed through the university's registrar, accused the two Aam Aadmi Party leaders of making sarcastic and defamatory statements in press conferences and on Twitter handles targeting the university over PM's degree. Today, a bench of Justices Hrishikesh Roy and S.V.N. Bhatti dismissed the petition, pointing out that the top court had in April this year dismissed a petition filed by co-accused Sanjay Singh challenging the same proceedings. Observing that the court must follow a consistent approach, the bench said that it was not inclined to entertain Kejriwal's matter, having regard to the view taken in Sanjay Singh's petition. At the same time, the bench clarified in its order that all contentions are left open to be decided in the trial and that it has not gone into the merits of the matter. In the next update today, a status report has been filed by the Kerala police opposing grant of anticipatory bail to Malayalam actor Siddiki in the rape case registered against him based on allegations levelled by a young actress. Following the publication of Justice Hima Committee report regarding exploitations faced by women in Malayalam cinema, the victim in this case made public allegations that Siddiki sexually exploited her in 2016 when she met him in a hotel room after he offered her opportunities in the film industry. Following her public allegations, she lodged an FIR. Last month, the Supreme Court had granted anticipatory bail to Siddiki. The status report now filed states that Siddiki is an extremely influential person in the Malayalam film industry, and the ongoing investigation reveals his ill intent to destroy evidence and threaten witnesses. It is also stated that he has not cooperated with the investigating agencies in the ongoing investigation. Further, the Kerala police have sought further custody and has claimed that the witnesses who have boldly come forward after the Justice Hema Commission report will step back if the interim protection to Siddiki is indefinitely prolonged. A bench of Justices Sanjeev Khanna and Sanjay Kumar of the Supreme Court today heard a petition filed to challenge inclusion of the words socialist and secular in the preamble to the Constitution by the 42nd Amendment. The petition has been filed by Balram Singh, senior BJP leader Dr. Subramanian Swamy and advocate Ashwini Kumar Upadhyay. They argue that the preamble was a declaration made on 26 November 1949 and adding new words to it through later amendments is arbitrary. They claim it is incorrect to suggest that as per the current preamble, the people of India agreed on that date to make the country a socialist and secular republic. The petitioners also stated that if this kind of amendment is accepted, it could lead to a precedent for future amendments to remove words like democratic from the preamble. Justice Khanna explained that the words added by 1976 amendment were clearly marked with brackets, making it obvious that they were introduced later. He also highlighted that terms like unity and integrity of the nation were among the additions made through this amendment. Justice Khanna further said that several judgments have affirmed that secularism has always been part of the basic structure of the Constitution. He pointed that terms like equality and fraternity, along with the rights in Part 3 of the Constitution, indicate that secularism is a core feature. Ultimately, the matter was listed for hearing in the week commencing 19th November. And now an update on the Rajasthan Civil Judge Exam 2024. You are aware that the police file state that while the candidates had performed overall well, it is alleged that they have been marked unjustly low in the range of 0 to 15 marks out of 50 in the English essay writing paper, thus denying them fair eligibility for the final interview stage. On the last hearing, the court had directed production of those answer sheets where candidates have been marked below 15 marks for the English essays. Today, Solicitor General Tushar Mehta, appearing for the Rajasthan High Court, informed that 7 trunks have been produced containing the English essay papers. The SG informed that 3,534 candidates appeared for the English essay mains, out of which 3,384, that is 95%, secured marks between 0 and 15. SG added that about 200 candidates who scored low in English essay were called for the interview considering their high scores in the law papers. The bench was told that the topics given for English essay were acquittal and honourable acquittal, Rajasthan festivals, Chandrayaan mission, etc. The bench led by CJI Chandrachud noted that the candidates who have not been called for the interviews have been informed of their marks and have been given the mark sheets. The bench remarked that it was unlikely that a candidate who scored good marks in law papers would score 0 marks in English, since the law papers were subjective in nature. The court has today asked the Rajasthan High Court to furnish a tabulated chart indicating the scores of 2 law papers obtained by those candidates who got low scores between 0 and 15 in the English essay paper. In the next update, a division bench of the Delhi High Court comprising Chief Justice Manmohan and Justice Tushar Rao Gadela today heard the ongoing defamation battle between Wikipedia and Asian News International, that is ANI. ANI had filed a defamation suit against Wikipedia for allegedly defamatory content on its page, accusing Wikipedia of harming its reputation. A single-judge bench of Justice Naveen Chawla, who is hearing the matter, had previously ordered Wikipedia to provide details of 3 individuals who edited the page. But ANI claims that Wikipedia failed to comply. The division bench is seized of the adverse comments made against the single judge on another page of Wikipedia, which was prima facie contemptuous. During the hearing, the court today said that being labelled as a puppet of an intelligence agency or a government stooge is the worst thing that can happen to a news agency. To Wikipedia, the court said that if the platform hides behind the label of an intermediary and refuses to disclose the author's identity, it would create a shield of anonymity that hinders the legal process. The court expressed concern that the ANI would have no defense if it is called a stooge of an intelligence agency. The bench made it clear that the news platform ANI must have a remedy and defense in the court, especially when such severe accusations are made. Acknowledging Wikipedia's valuable role as an open source encyclopedia, the court warned that it is vulnerable to manipulation. Further, referring to the page on Wikipedia that was based on the proceedings before the single judge, the Chief Justice stated that the page inaccurately suggested the court had threatened to shut down Wikipedia, that the court was intervening to solve the issue and it was not right to make contemptuous remarks against it. When it was informed that Wikipedia had taken down the page on the pending defamation proceedings, the fresh contempt plea moved by ANI against Wikipedia for failing to comply with the takedown order in the time was then closed. The bench has now directed the parties to file their responses and has listed the appeal for hearing on 28th October. Today, the bench was further dismayed to note the justification provided by the ministry. Not just the DRT Visakhapatnam, but all DRTs across the country were asked to collect data. The bench noted that the data was sought on the number of cases with DRT amounting to Rs 100 crores and above, total number of new cases filed, amount recovered, etc. The council appearing for the ministry said that the data was sought for the purpose of holding a meeting with all stakeholders on how to improve the system. But the bench said that if the ministry wanted data, it should deploy additional resources instead of tasking the DRT officials with it. The court orally said that the ministry cannot treat the judicial staff of DRT as its subordinates. The court has now asked the secretary of the concerned department to look into the matter and ensure that a proper affidavit is filed in response to the court's September order. In another update, the Supreme Court has today decided to lay down guidelines on the conduct of advocates on record after discovering false statements made in a case to seek remission for a client. A bench comprising Justices Abhay S. Oak and Augustine George Massey has appointed senior advocate S. Muralidhar as amicus curiae to assist in this matter. In this case, 2 senior advocates had filed affidavits in the matter regarding the false statements. The bench noted that the senior and the AOR were blaming each other. The court emphasized the need to correct systematic issues rather than proceed against individuals and highlighted the crucial role of AORs in ensuring that no litigant can seek redress from the court without their involvement. The matter will be considered further on 11th November. I must also tell you, recently the Supreme Court had ordered CBI inquiry in another matter where a fake special leave petition was filed without the knowledge of the client by forging his signatures. And lastly, the Supreme Court today allowed Justice Jayant Nath to continue as the chairperson of Delhi Electricity Regulatory Commission, regardless of attainment of the age of retirement, that is 65 years. Justice Nath was appointed by the Supreme Court in August 2023 on a pro-term basis in view of the deadlock between the Delhi government and the Delhi Lieutenant Governor regarding who has the power to appoint the DERC chairperson. This issue, let me tell you, began when the previous DERC chairperson retired in January 2023 and the position remained vacant for around 4 months. The Delhi government proposed appointment of Justice Rajiv Kumar Srivastava, but the LG delayed action on this, seeking legal advice on whether Chief Justice of the Delhi High Court needed to be consulted. Then in May 2023, the Supreme Court clarified that only concurrence of the Chief Justice from the High Court of the retired judge was required and not the Delhi High Court's Chief Justice. After Justice Srivastava declined the position, the Delhi government proposed Justice Sangeet Lodha. However, the President appointed Justice Umesh Kumar, which the Delhi government objected to. Following disagreements, the Supreme Court ultimately appointed Justice Nath as the chairperson. Since Justice Nath is about to attain the age of 65 years soon, an application was filed by the Delhi government seeking to allow him to continue. The counsel for both the Delhi government and the Delhi Lieutenant Governor agreed that Justice Nath can continue till the dispute between the Delhi government and the union government regarding the powers of appointment is settled. For more details on the cases mentioned here, please visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe to our channel. You can support us by donating through the thanks button at the bottom of our videos or by becoming a member for just 89 rupees per month.